On January 26, 1992, the Dow Jones Industrial Average was 3,172. On January 26, 1992, the cover of Life magazine was entitled 1991, The Year in Pictures. It included pictures of various people in the news, including Anita Hill. On January 26, 1992, Title III of the Americans with Disabilities Act went into effect. What did not happen on January 26, 1992? The sale online between two friends of a CD by Sting. How do we know that that online sale did not happen on January 26, 1992? We know it because it was 31 months later, in August 1994, that the New York Times reported the sale of this CD between two friends with the headline, "The Internet is Open." The Times wrote, "The team of young cyberspace entrepreneurs celebrated what was apparently the first retail transaction on the Internet using a readily available version of a powerful data encryption software designed to guarantee privacy." Good afternoon. I'm Doug Mishkin, a partner with Venable and its Labor and Employment Group. 24 years after that New York Times article, e-commerce has exploded, and with it, so has the importance of the accessibility of websites to people with disabilities. The importance of the issue is underscored by the fact that in addition to those of you with us in person here in New York, there are over 200 of you listening in via the webinar. We welcome you all. We have a lot of ground to cover in our brief time together, so I will do my best to make this introduction as long as possible. Housekeeping matters. This program is accredited for CLE credit. We'll be fielding questions throughout. For those who are joining us via the webinar, please listen for the CLE code at the end of the presentation today. You will need the code in order to receive credit. This program is interactive. We've left time for questions at the end. We'll do our best to address as many as possible. For those joining via the webinar, please chat us your questions using the Q&A function on the webinar platform. If we don't get to your question, we will follow up with you individually after the program. Today, you're going to hear from three speakers. Nick Ryder is counsel in our Labor and Employment Group in New York. Like several of us in the group, he spends more and more of his time counseling and defending clients in litigation about issues of website accessibility. And Nick is far and away the biggest wise guy in our group. Karl Masnick is an associate with the Labor and Employment Group in Washington, D.C. Karl works closely with me on website accessibility, client matters, and writes frequently about these issues. He's not as much of a wise guy as Nick, but he is getting there fast. About a year and a half ago, it seemed like someone threw a switch, and we started getting these calls regularly. Now, we knew that in addition to legal advice, our clients needed a consultant who could advise on the technical side of things. What needs to be done to your website to enhance its accessibility, and what's the cost-effective way of doing that? I called a friend of mine who is a veteran ADA lawyer in the Justice Department, and I asked her, who should my corporate clients talk to about the technical piece? And since then, I have thanked her repeatedly for referring me to our third speaker, Ken Nakata. Ken is a former Justice Department lawyer who did these issues at the Justice Department. He left there years ago to focus on these accessibility issues. We refer our clients to him regularly, and we are delighted that he is with us today. I don't know Ken well enough to know if he's a wise guy, but on these issues, he is certainly wise. So for today, that will have to do. Let's get started. Nick Ryder will talk to us about the ADA itself.
Thanks, Doug, and thanks to everyone both here physically in our conference room and the many folks we have listening online. We're very glad you could make it out to today's program. And today we intend to offer some information regarding the wave of website accessibility litigation that we've been observing over the past year or two. And there's no secret, really, that this topic is one of the new favorite toys of the plaintiff's bar. So we want to offer some tips for compliance, as well as some advice and observations we're seeing for the best defenses that are out there in some of the recent cases. But we don't want to lose sight of one thing here, and I want to mention it from the outset of the program. You know, if you work for a company or an organization that offers any types of goods or services to the public, making your website more accessible, it's not probably just the right thing to do. It's not probably just what's legally required of you, but there's also probably a business case to be made for making your website more accessible. The World Health Organization estimates approximately 36 million people worldwide are completely blind. It estimates approximately 217 million more people have moderate to severe vision impairment. So that's about 250 million people who might be potential consumers, potential people out there who can't access your company or organization's website, but who might buy your goods or services otherwise. So that's just something to keep in mind as we go through today's program. Now, in terms of what we're going to cover today, the program objectives, first you're going to hear from me. I'm going to give you a high-level overview of the different laws that are in play here for website accessibility. Next, I'm going to hand things off to Ken Nakata, former DOJ attorney, and he's going to discuss some best practices for bringing your website into compliance and some easy strategies there. After that, you're going to hear from Karl. He's going to discuss litigation trends and offer some examples of what we've seen for successful and both unsuccessful defenses in the handful of cases that have been coming to judicial decision around the country. And finally, as Doug mentioned, there will be some time for a Q&A. Also, we're going to hang around after the end for the folks in the room who want to ask questions. And I think our emails are provided in the materials. We're happy to answer anybody's questions afterwards via email also. So 1990 comes along, and we get the Americans with Disabilities Act. And it was really the first comprehensive federal law that was prohibiting disability discrimination. And it's divided into three titles, three sections really. You have Title I, that's your employment disability discrimination protections. It prohibits employers from treating disabled employees differently. They have an affirmative obligation to reasonably accommodate employees so long as it doesn't pose an undue burden. And also in the failure to hire context, you can't treat a disabled job applicant any differently than a non-disabled job applicant, and I'll touch upon that a little bit as it relates today to today's program. Title II, that's your government programs and services, not really the focus of today's program, but just by way of example, that's your fire department or your police department. Those government services have to treat disabled persons the same as non-disabled persons. And then you have Title III, that's really the meat and potatoes of today's program, public accommodations. And that requires that a place of public accommodation cannot deny the full and equal enjoyment of goods and services to a disabled person. And back in the 90s and early 2000s, those of you listening and those of you in the room today, you might remember there was the wave of wheelchair accessibility lawsuits. It wasn't uncommon for a wheelchair user to go to Fifth Avenue in New York City, go up to each clothing retailer or restaurant or bar and see which establishments he or she could access, and then there might be 30 lawsuits filed the next day against each of the establishments that didn't have access for a wheelchair user. Those lawsuits still exist, but they've gone down in frequency somewhat. But what they've been replaced by are, in some part, is the website accessibility cases that we've seen over the last couple of years. And as Doug was alluding to earlier, part of the reason is back when the ADA was written and enacted, e-commerce wasn't nearly what it was today. The internet didn't really exist as it does today. And so you have a somewhat of an outdated statute being applied by judges to a new state of e-commerce. And adding to the difficulty is some of the lack of regulatory guidance on this topic. During the Obama administration, the Department of Justice suggested that it was going to go through the rulemaking process and issue regulations for the applicability of the Americans with Disabilities Act to website accessibility. But then just last year, during the Trump administration, the Department of Justice put that on the back burner and put that rulemaking process on the inactive list. So there's nothing to suggest that we're going to get any regulatory guidance on this issue anytime soon. What that leaves us with is the judiciary. That's the branch that is going to give us some guidance. And what we want to cover right now are the three elements for a Title III claim and offer some tips, as my other presenters will, about how to comply with those elements. First, the plaintiff has to be disabled within the meaning of the ADA. And for most of these claims, that's not contested usually. Second, the defendant must own, lease, or operate a place of public accommodation. That's often hotly contested, and there's a split in the circuit courts that we'll talk about in a moment. And third, the defendants have to discriminate against the plaintiff by denying the plaintiff the full and equal opportunity to enjoy the goods and services. And that's often contested too, but that more relates to the type of access to the goods and services. So element one, who can bring a claim? That's your vision impaired consumers, and that doesn't necessarily mean completely blind. That just means someone with a vision impairment. It could mean your hearing impaired consumers, again, not necessarily completely deaf, just someone who doesn't have full range of hearing. And that would be particularly important to a company or organization that might have an audio component like video on their websites. It can also be learning disabled. There can be cognitive disabilities and impairments that also have to be accommodated. Again, not usually contested, though, in this type of litigation. The second element, though, public place of accommodation, is often a big dispute. And the Americans with Disabilities Act, it sets forth 12 statutory categories that you see up here on slide 6 for what constitutes a place of public accommodation. I'm not going to take the time to read through them all now, but as you can see, it's very expansive. It's really almost any type of establishment that offers any types of goods or services. I mean, it runs a wide gamut of, obviously restaurants, bars, cafes, schools, parks, museums, insurance offices, lawyers' offices, healthcare providers, hospitals, anything really where goods or services are being offered. But what's missing from this slide? Websites. And that's, again, because when the statute was written and enacted, the internet really didn't exist as it does today. And it wasn't contemplating the e-commerce world that we have right now. And what that's resulted in is this split between various federal courts around the country. And you really have primarily two different approaches. In district courts in the First, Second, and Seventh Circuits, those courts have taken an approach, a more plaintiff-friendly approach, where Title III of the ADA will apply to any type of internet activities that fall within one of the 12 statutory categories that were up on the prior slide, which essentially means if any types of goods or services are being offered through the internet and those goods or services qualify under those 12 categories, well, then the ADA is going to govern the website accessibility for that site. In contrast, the district courts in the 3rd, 6th, 9th, and 11th circuits, they're taking a nexus approach. Those courts are requiring that there's some type of connection or nexus between the internet activity, the website really, and then the actual physical place of public accommodation. And they're drawing that approach, the rationale for that approach, from the words in the statute that say, quote, place of public accommodation. And my co-presenters will talk a little bit more about that second approach later, but to give you an example, courts might look to a website that, if it offers the store's location hours, the operating hours for the brick and mortar location, if that's displayed on the website, that might be a sufficient nexus. Or if you can go on the website and buy goods and then pick up those goods at the physical store rather than have them shipped to you, that might be a sufficient nexus that would, under which the ADA would then apply. So the third element is the denial of full and equal enjoyment of goods or services. And unlike the second element, which is really considering whether the website is even a place of public accommodation, this third element is going to focus on the type of access that the disabled website user might have to the goods and services. And really, this fourth bullet point is probably the most important, in my opinion, for this final element. It's where courts are going to engage in a fact-specific analysis about the type of access that a disabled user might have versus the type of access that a non-disabled user might have. And I think one hypothetical that Karl might go into more detail later, but think about this. In lieu of making a website accessible to vision-impaired users, a business might create a 24-hour telephone hotline where blind users can call in and order goods that way. Well, you might say, okay, that's an alternative way for them to order goods. They don't need to make their website accessible. But a court might look to the average wait time in that instance. Because remember, e-commerce is pretty instantaneous. You click on what you want, you put in your credit card information, your shipping information, and you're done. And if the average disabled user has to wait 10, 15 minutes to speak to a customer service representative, that might then satisfy the third element for a Title III claim. I'd be remiss if I didn't mention that you should always consider the state and city laws that might be at issue. You might find yourself, especially if you're in one of those nexus jurisdictions, you might find yourself where the federal law might not apply to certain types of websites, but there might be more expansive coverage under state and city laws. The New York State and New York City human rights law, as well as the California Unruh Act, are all good examples of statutes that tend to provide more expansive protections, especially as it relates to damages, too. And you should also, for any government contractors, you should always check your government contractor requirements. It's not uncommon, as a lot of you know, for federal, state, or city governments to impose more onerous requirements than the law for the businesses with which they contract. And one thing to keep in mind is this, we think, has led to some forum shopping by plaintiffs' attorneys. That we've certainly seen a high proportion of cases filed right here in New York. So that's another, venue's always another consideration if you're facing a litigation. And finally, for me, and I mentioned this a little bit earlier, but there's Title I considerations. For any business or organization that has an online job application process, it's very likely that the ADA would apply to that process, that you have to make the online job application accessible to disabled users. And that would include information about the job requirements or job vacancies. And it's a very important consideration because in the Title III context, usually damages are capped. Usually either there's only equitable relief under federal law, or sometimes even under the state laws, the damages are capped at a relatively low level. But when you're in a failure to hire employment case, it's a different ballgame. You've got monetary damages like front pay and emotional distress on the table, and those are real wild cards sometimes when you're in front of a jury at trial. It's not uncommon for a jury to award hundreds of thousands of dollars, even millions of dollars, for a single plaintiff case for those types of damages. So if you have an online job application process, you want to apply the same accessibility requirements and standards that you're going to hear from us today. And with that, I'm actually going to hand it off to Ken to talk about some of those best tips for accessibility compliance.
Well, thanks, Karl.
I'm Nick. That's Carl.
I'm sorry. Thanks, Nick. Sorry about that. Carl's over here, Nick's over there. Yeah, I flew in from Seattle last night, so I'm using that as my excuse. So, before we get into what I was going to talk about, I should caveat this by saying that this usually presentation takes about an hour. I'm going to give it in about 10 to 15 minutes. And what's even worse is I'm going to add to it. So, as Karl was mentioning, this has been a big area in the plaintiff's bar. I think, though, it's even bigger than a lot of us really initially thought, because, you know, if you're, say, a person with a disability, or use a wheelchair, for instance, you go up to various business establishments. Yes, it's true that, you know, a lot of plaintiffs were filing serial lawsuits like that when they'd find a barrier. With websites, it's even easier. Now you could just be a plaintiff's attorney, sit in your office and use an automated scanning tool. Just pick out, you know, a couple e-retailers, find a couple barriers, call your friend with a disability who happens to be your nominal plaintiff. Boom, next thing you know, you've got a lawsuit. And when I look at a lot of the lawsuits that were filed back in the early days, in 2013, 2015, almost all those cases involved a similar set of fact patterns. And they almost always involved some elements that could be automatically tested. And I think that's one of the reasons why we're seeing certain law firms in this country filing hundreds, maybe even thousands potentially of cases. So, and the proportion of lawsuits that we're getting in web accessibility is such a big bulk of the ADA cases that we've seen nationwide that you can't help but think that this is like the new favorite toy of the plaintiff's bar, as Carl was mentioning. Carl, as Nick was mentioning. One day I'll get their names straight. Anyways, so it's as much as it's easy to think of this as just a money grab by the plaintiff's bar, there's also a lot of really important considerations that are behind the scenes. And I'd like to just touch on some of those ideas right now, because a lot of them, I think, drive some of the policy or social, some of the policy issues that are important in website accessibility. So according to the Census Bureau, 1 in 7 people have a disability. It comes out to about 40 million people in this country. Of those, the National Federation of the Blind tells us that about 7.5 million are blind or have a functionally blind. And what they mean by that is they need some accommodation beyond just simply glasses in order to do their job or just to get by in life. So that number, though, is just going to increase because there's another phenomenon that's going on in our society, which is that our population is aging. Of course, everybody's getting older. We can't help that. But the proportion of people in our society is getting older. I think that the statistics are that by 2040, what is it? 24% of our population is going to end up being over 65, which is going up from 15%, so about not quite doubling in proportion. But a big chunk of our population is going to be a lot older in the future than it is now. And with age comes disability. The number of people with disabilities basically doubles as you get into those age groups. And so a lot more people are going to be relying on the types of accommodations that we're talking about today. And so it's also vitally important that we make the internet accessible to that demographic because, well, chances are we're all going to end up there anyways, and a larger proportion of us are going to end up there. So now with that little policy spiel, I'll get on to actually what I was going to talk about today, which is how do you get around these problems? And in my day-to-day work, I advise companies on a pretty much a daily basis about how do you achieve web accessibility. And we use a 4-step model. The steps are, first, an accessibility statement. Second is manual testing of key use cases and templates. Third is automated testing. And fourth is what I call creating a culture of accessibility. And I'll discuss each of those elements separately. First, you've got the accessibility statement. And I think that's probably the number one thing that most organizations can do and should do for accessibility. It's also the simplest. You can do it basically now. It comprises of 3 elements. One is an accessibility policy, which is pretty much just setting forth your goals, which in most cases will be achieving WCAG 2.0, for instance, the Web Content Accessibility Guidelines 2.0, level A and double A. That's sort of, well, I think of that as a safe harbor in terms of web accessibility. There are no current standards that are required by the Justice Department, as Nick had mentioned, but in all the settlement agreements, that's the bar that they settle at. So we can pretty much safely say that WCAG is the standard that you want to be shooting for. Next is contact information, and this is absolutely vital. The reason is because if you provide contact information like a telephone number, as Nick had mentioned, that's vital in trying to make sure that a person with a disability is able to access goods and services. But it's also essential under the concept of effective communication, which is part of Title III's requirements. Title III generally requires that you have to be non-discriminatory in access to your goods and services. One of the ways you achieve that is by ensuring that communication is effective between you and your consumer. And providing that contact information may be critical in offsetting the effective communication requirement while you're trying to achieve, website accessibility. The third is a feedback mechanism, and this is where you allow people with disabilities or any of your customers to give you comments on feedback about your website and the locations in which there are accessibility problems. That serves two purposes, really. But most important of them is that it allows it serves two purposes. First, it lets you know where there are problems that you may have overlooked. But the second reason to do it is it can diffuse a lot of customer service issues that might otherwise end up in court. Okay, so now we get into the more technical, boring stuff. Manual testing of key use cases and templates. There are certain portions of your website that really have to be manually tested, and this means having a tester who's familiar with assistive technology go through your website and actually look for the main issues that keep coming up in a website. So what do I mean by key use cases? Well, that really comes down to, why do people go to your website? So for instance, if you're an e-retailer or e-commerce site, people probably come to your website to search for a product, add it to a shopping cart, read reviews, do the checkout procedure, things like that. And so that would obviously be a key use case for an e-commerce site. Then in addition to that, there are the template pages. Those are pages that might not be part of those key use cases, but provide a structure that is common to a lot of web pages. So for instance, if you've got headers that are repeating, or you've got a menu structure that's repeating, or you have the footers at the bottom of your page where you put your privacy statements and things like that. If that content repeats across dozens of web pages, you want to make sure that at least some of the pages that include that content are part of the pages that you consider as part of your manual testing. And in doing that, you can get really complex websites that have thousands of pages reduced to a very finite set of web pages that really require manual testing. And in our experience, it rarely comes out to more than 50 pages that absolutely have to be manually tested. So what goes into manual testing? Well, we have a person who's obviously very experienced with assistive technology that'll go through a web page. First thing that they'll do is they'll try just doing a keyboard-only pass, which basically means, can I access that page and all of its content using just my keyboard and not using a mouse? Because if you're blind, you're probably not using a mouse. Then the next step is going through it with a screen reader. And that means taking something like JAWS, which stands for Job Access with Speech. And it's a popular screen reader, and just going through the content to make sure that everything is being read out. Generally, an experienced tester will be able to get a good sense about the accessibility of the page from just those two steps. But sometimes there are little nuances in the web page that require additional rounds of testing, and that can involve the use of a screen magnifier or voice command software like Dragon Naturally Speaking. So one of the issues that often comes up in accessibility testing is whether it's necessary to have a person with a disability testing. And I think it's a really good idea. It's particularly important for getting a sense of the usability of the site, but not necessarily for getting to know whether you can whether the site follows the specific WCAG 2.0 A and AA standards. The reason for that is, the reason I feel that way is I used to work with a federal agency that had all blind testers, and sometimes they would go through a web page and test it, and there's entire sections of the website that they would, entire sections of a web page that they would completely miss. And the reason for that is because they didn't know that it was there, basically. So if you have a disabled user doing the testing for WCAG 2.0, then they also have to be accompanied by someone who isn't visually impaired so they can make sure that they're actually hitting all of the visible content. The key point, though, is to make sure to always test to the WCAG 2.0 standards. As I mentioned before, that's the thing that's a set of standards that the Justice Department and the plaintiffs' bar are really holding us to. So the next step is automated testing. And here, this is important for enterprise websites that have thousands of web pages. Because realistically, you can't manually test every page on a website. Manual testing is great because you can get at all of those WCAG 2.0 standards. The problem is that it takes about a half hour per page to test. And say your contractor is charging $250 an hour, that's $125 per page. You get a couple thousand web pages, and next thing you know, you're butting up against $1 million. And that's not within most people's budget. So automated testing plays an important role for the larger websites. So here, automated testing really needs to focus on a few very essential key issues. About, let's see, 5 years ago, I did a review of all the complaints and settlement agreements I could get a hold of. And there were 4 key issues that kept recurring over and over again. There were missing alt attributes on images and on image maps, bad table markup, and missing labels in electronic forms. And that might, depending upon my audience, some of that stuff may just go right over some people's heads, but I'm sure a lot of people know what I'm talking about. These are fairly basic things that can be done to a website to make it accessible. And back in 2013, I noticed that these issues kept coming up over and over and over again. They're some of the most important accessibility issues, but there are only 4, actually only 3 of the WCAG 2.0's 38 A and AA success criteria. So really, automated testing can only test a small portion of the 38 success criteria in WCAG 2.0, but they also test some of the most important ones. And those same issues, as I mentioned before, are also the key ones that keep coming up over and over again in these drive-by lawsuits that we keep seeing. And I bet that a lot of law firms that are on the plaintiff's side are using automated testing tools to at least initially screen e-commerce sites to figure out who to sue based upon things like whether those 4 elements are met. So if you address those issues with automated testing, I believe that your chances of being picked up and being seen on the radar, if you will, of a plaintiff that's interested in a lawsuit are going to be drastically diminished. So in addition to that, there's the benefits of there are the advantages of automated testing in terms of accountability and tracking and things like that to make sure that things are being caught. And another nice feature is that it gives businesses metrics in terms of how well they're achieving web accessibility. Okay, so those 2 elements, manual testing and automated testing, are really a temporary fix. They can take care of a website for the moment, but that doesn't mean that future web development is going to be accessible. So here we get into this idea of how do we create a self-sustaining culture of web accessibility. And to do that, what we found is the simplest way, and this is something that is surprisingly simple, is to use checklists specific to different stages of the specific to each stage of the web development process. So if you think about a web development process, if you go to, say, Digitas or one of the other major web development firms, they very often use a process of the design, copy, and the development. And there are different stages of the web development process, as I mentioned. The design stage is where you're looking at the wireframes. It's really where the artistic people have an opportunity to create their vision on a piece of paper. The copy people are the people who actually write the content or the words that go on a site. And then the development people are the people who actually code the website. Well, what we did was, we started this with a major IT vendor up around Boston. What we did for them is we broke out WCAG into very specific requirements. So if you've ever read the Web Content Accessibility Guidelines, you'll know that it's a fairly abstract document, especially when you read the success criteria. What we did was we took each of the success criteria and made a requirement very tailored to each of the different stages of web development process. And that checklist is ultimately traceable back to WCAG. We gave each group within the web development process a separate checklist, and then we also made sure that when they received received a design from the last person in the web development process, that they had an input checklist. So there was a set of outputs and a set of inputs that each group was expected to meet. The input checklist is actually vitally important because it ensures that the person who last touched this website design included all of their requirements and made sure that they did the process right. So in that sense, it becomes self-policing. So we found that this process really worked quite well for web development, and it had a number of advantages over other strategies. It's flexible, works across different web development processes like waterfall or agile development processes. It's self-policing because every group monitors what's coming in and what's going out, and by monitoring what's coming in, they're able to make sure that the last group actually did their job. It eliminates backloading to the developers. Well, very often what happens is that organizations say, oh, great, we've got WCAG 2.0, let the developers handle it. And they get stuck doing everything, and that causes a lot of frustration. It also enabled our clients to create much more targeted training that's really relevant to each of their job roles. So they're not being taught this abstract set of requirements. They're actually being taught things that are very specific to their job functions. And lastly, as I said, it creates a self-sustaining culture of accessibility. So once we set that up, it almost runs itself. So let me just briefly summarize those 4 tips. One is creating an accessibility statement. Most important element there is the contact information. Second is the manual testing, primarily around the key use cases, or in other words, the reason that you visit a website, as well as the repeating content across websites. Third is automated testing of those 4 key elements that I mentioned that seem to keep recurring across lawsuits. And lastly, there's this idea of incorporating checklists so that everybody within the development process, no matter what their role, knows what to do in terms of helping achieve accessibility. And with that, I will hand it over to Karl.
Thank you, Ken. All right. So you've heard from Nick on the state of the law. You've heard from Ken on some of the practical considerations. I'm going to address some of the legal cases and the legal trends that we've noticed, some of the common defenses, and some of the potential remedies and damages for noncompliance. The most striking trend that we've seen is the sheer number of website accessibility lawsuits filed in really the past year and a half. Now, Doug mentioned that it was almost like a light switch went off about a year and a half ago. And really what this comes down to is before 2015, these suits were relatively rare. Since 2015, the number of suits filed has grown exponentially. And this year alone, in just the first 6 months, we've seen over 1,000 suits filed in federal court, not even counting the website accessibility lawsuits filed in state court or those matters that settled before a suit was ever filed, which I mention incidentally because these cases do tend to settle and settle early. The next trend that I want to point out is that a lot of these suits are concentrated in just a number of jurisdictions. Now, we have seen suits from a large number of states, but when you look at the sheer volume of lawsuits filed, they tend to come in within these pockets of activity. The foremost being right here in the Southern District of New York, where we've seen over 530 new complaints just since May of this year. The Florida, Pennsylvania, California are also popular. Massachusetts, which is not up there, has also seen a lot of activity this past year. But the reason that one of the reasons that we see this, as Nick and Ken already addressed, is this drive-by lawsuit phenomenon, which I'm not going to go over again, except just to say that it's not uncommon for a single firm to send out 10, 20, 50 demand letters based on just one plaintiff or a group of plaintiffs. I should also say that this does not mean that it's only the New York or Florida companies that are being sued. If your company sells goods or services through your website, you can be sued in any of the states. But as Nick alluded to, oftentimes it's the plaintiff that selects the forum, and they tend to select the forums that's usually more favorable to them. And I'll get into that a little bit more when I talk about the potential remedies and damages. One thing that I do want to touch on is the class action lawsuits. Of the suits that we've seen, a relatively large number of them have been class actions filed on other similarly situated consumers, usually visually impaired consumers. And again, this becomes very important when it comes to adding up the statutory damages available under certain state laws or the remedies. The next trend that I'd like to touch on is the different industries that have seen these suits. Now, we've seen complaints, demand letters across a large number of companies, different varieties of websites, but the industries here are the most frequent. And the retail, restaurant, hospitality industries lead the pack. We've also seen a large number of suits filed against universities and educational institutions, banks, credit unions, among others. The next thing I would like to point out is that while a lot of this focus is on website accessibility, rightly so, companies that have mobile applications face the risk of the same exact types of claims. And I have on there this Sweetgreen matter, which I thought was a good example. Sweetgreen, as you may be familiar with, sells salads or rice bowls, roots. I'm not sure what they. But it's the point is you order your food through the app. You customize your salad or your meal, and then you have it ready to pick up when you go to the store. Well, in 2016, they got hit with a lawsuit which claimed that both their website and their mobile app were not accessible, and it was a class action. It ended up settling. The point being here is that in the settlement, they agreed to make both the website and the mobile app accessible. And especially these days, with more and more companies coming out with mobile apps, you should be aware that these sorts of issues are relevant also to those in addition to all the websites. And the last trend that I'd like to talk about is while our presentation is based on U.S. law, these issues are not limited to the United States. There are many other nations out there that have required their public websites to be accessible. For example, the European Union now requires, or will very soon require, their public websites to comply with WCAG 2.0 AA. And there are also a number of nations which require private websites to be accessible. Amongst those are England, Canada, Australia, Norway, just a couple of examples. So for any company out there who has a website that sells goods abroad or is otherwise targets markets abroad, be aware of the law in those nations. All right, I'm going to switch track on you for a little bit and talk about the different legal defenses. And in the interest of time, I'm just going to touch on these very briefly. The very first and the one that we get asked about the most, which Nick alluded to, is the alternative, the accessible alternative, oftentimes being the phone number. So the idea is, if my website is inaccessible, can I provide the same information or goods or services over the phone? And does that satisfy the law? And the answer to that is unclear. I'm sorry, it's not clear. The reason is there's just not enough case law out there that has addressed these specific issues. Some cases, like the Domino's case, has suggested that it might be enough to satisfy the ADA. And the DOJ has, in its previous statements, taken the position that companies might have some flexibility when it comes to their effective communication requirements. Other cases have rejected this argument. For example, in the Dave & Buster's case, the company did have an accessibility statement, did have a phone number on the website, but the court rejected the argument because, well, it was on there, but there was no evidence in the record to show that the phone number itself was accessible. So you can have it on the website, but somebody who's relying on a screen reader might not be able to read that site, might not be able to access that phone number, which by and large defeats the purpose. Right? The Blue Apron case is another interesting example where the court allowed for the possibility that this might be enough, a phone number might be enough to satisfy the ADA, but it ruled that this was a fact-intensive inquiry, and it was inappropriate at a motion to dismiss stage to address this, which underlines the major issue here in this evolving area of the law where we don't have a lot of cases to begin with. Most of the cases that we do have are in the motion to dismiss stage where the courts will not address these fact-intensive inquiries like the phone alternative. I would like to highlight the Midvale Corporation case for you, though, because that's one of the few cases that addressed the issue on summary judgment. And it's exactly the case that Nick highlighted earlier, which is they did have a phone number, but it was only available during business hours. And so the court said this was not enough to satisfy the ADA because disabled consumers would have to wait until the next business day, maybe next week, to get assistance, and the court said that was simply not enough. All right, so the jury's still out on this issue. It may very well be that the courts come down and say that a phone line that's staffed 24/7 with customer reps who are familiar with these sorts of issues, can handle these sorts of complaints, is enough to satisfy the requirements. But in the meantime, as Ken already said, it's a good intermediate step for your accessibility statement for companies that are definitely going to remediate their website, but in the meantime want to provide an alternative access to goods and services. All right, the next group of defenses I'd like to cover are standing and personal jurisdiction. We've seen the standing argument come in from a group of credit union cases that center around the premise that the plaintiff didn't have enough connection to the credit union, right? So they didn't have, for example, in the Carroll case, the plaintiff lived over 300 miles away from the nearest branch of the credit union. And so the court looked at the complaint and said, well, you're not going to be a customer for this branch anyways. You haven't alleged a particular injury, and dismissed the case for lack of standing. This sort of argument can be transferred to other types of cases, but we've really only seen it, or we've largely seen it in the credit union context. The personal jurisdiction cases are a little bit different. They've been less successful. In those cases, it's the defendant that argues, I don't have enough of a connection to this particular state or this particular venue, and so I can't be sued in this particular court. So in the sportswear case, the company sold goods through its website. It was sued in Massachusetts, but it had no employees, it had no offices, it had no property in Massachusetts, and it had a very small percentage of its sales, it was like less than 4% of its sales come from Massachusetts. But the court still ruled that it had personal jurisdiction over the company, in large part because the court ruled anyways, it deliberately targeted the Massachusetts market. And it relied on the fact that the company sold apparel that had logos of Massachusetts sports teams, right? So it was showing that the company directly targeted Massachusetts consumers. The next defense is mootness, based on the premise on that if I've already fixed a lot of the accessibility issues to my website, if I've already made it compliant with WCAG 2.0 AA, for example, then you don't have a basis for that claim. And we've seen this argument have mixed results. And it's really largely dependent on just how far along in the remediation process you are. So in the Five Guys case, the court did not rule that the case was moot. It allowed the case to proceed because the company just started the remediation process. In the Carroll case, the opposite happened. The court ruled that the case was moot, threw it out, and it did so because it held that the allegations were based on a website that no longer existed. The remediation process had proceeded far enough in the court's judgment. The Hooters case is interesting because that's based on a prior settlement. So the company had already been sued by a whole other plaintiff less than a year earlier, and then as part of that settlement agreement, the company agreed to remediate its website. So when this new complaint came in, the company tried to get the case dismissed to say, we've already agreed to all of the relief that you have requested. But unfortunately for the company there, the 11th Circuit disagreed, and it ruled that the case was not moot based on a number of factors, including remediation wasn't complete yet, and that the relief sought by the new plaintiff wasn't completely addressed by the prior settlement, so that the relief didn't match up. All right. The last group of defenses are due process, primary jurisdiction, and failure to state a claim. The first two are largely been unsuccessful. The due process argument's based on the premise that because the DOJ hasn't issued regulations, the company doesn't have enough notice of its legal obligations. And the primary jurisdiction is slightly different. It's based on the idea that the technical standards are so complicated that the DOJ should first rule on the issue before the litigation is settled. Both have largely been rejected except for the Domino's case, where the plaintiff alleged that the company had to comply with WCAG, with the technical standards, as opposed to just simply saying you have to make your website accessible, which is what's required under the law, absent any regulations. Right. And the last defense, failure to state a claim, it's going to vary largely depending on the facts of the case, the jurisdiction. But one of the common examples that we've seen is if your website or your company doesn't fall into one of the 12 enumerated categories that Nick went through. So, for example, a purely informational website that doesn't sell goods or services or doesn't otherwise fit into one of the 12 categories might have a successful failure to state a claim defense. All right, I think I'd like to move on to remedies. And this is important because in all of this discussion, it's often lost that under the federal law, under the ADA, you're not entitled to monetary damages. You're only entitled to injunctive relief or reasonable attorney's fees and costs. The injunctive relief can be anything from making your website accessible, comply with WCAG 2.0 AA, hiring a consultant to do that, putting up an accessibility statement or policy, or auditing the website for a set period of time, all of which can be time-consuming and expensive for a company anyways. But I put on there monitoring cost as a separate point because we've seen a number of cases where courts have awarded the plaintiff the cost they incurred in monitoring the website up to filing the lawsuit, figuring out what are the accessibility barriers, and afterwards monitoring costs for that set period of time and auditing that website for, say, 1 year or 2 years. And then attorney's fees and costs. I do want to talk briefly about state laws because state laws offer all of those. In addition, some states also offer monetary damages, which are usually statutory damages capped at a certain amount. For example, California. I've also seen some complaints in New York that seek monetary damages. Even though they're oftentimes capped in big class action cases, for example, the big famous Target case, these do add up. And that case ended up settling for $6 million plus close to, I think it was $4 million in attorney's fees, in the plaintiff's attorney's fees. So that's an extreme example, but it shows just how far these statutory damages can go. I did lastly want to highlight the Midvale Corp case, which addressed statutory damages. In that case, the plaintiff tried to access the website 5 or 6 times and then tried to get damages for each of those attempts. But the court limited it to one violation of the law and said, you're only entitled to the $4,000 under the law for one violation and not for each individual attempt.
Pretty quickly, we're going to bump up against our self-appointed deadline. So let me address a few matters before we adjourn. Before I get to some questions that have come in, a couple of slides ago, Karl mentioned this question about if you've already revamped your website or are in the process of doing that, is that going to work as a defense if you're sued? And I want to call everyone's attention to the fact that Karl has written a piece about that might be of interest to you. It should be of interest to all of us because this is a phenomenon that's going to occur more and more. And you can find that piece at the Venable website, or if you email Karl, he'll direct you to it. Questions. One question has come up asking whether all that we're talking about applies to nonprofits that are engaged in giving away goods and services. And I think there really are 2 pieces to this question. One, does this stuff apply to nonprofits? And then it's nonprofits who are not selling goods and services, but rather giving them away. I see a flicker of recognition in Nick Ryder's eyes. Go for it, Nick.
Yeah, I would say the answer is certainly yes. If you look at the 12 statutory categories, food banks, for example, are listed. I mean, that in most cases, that's going to be a 501c3 charitable organization, nonprofit organization, and their entire enterprise is quite literally giving away food for free. So I would certainly say, subject to the nexus approach or the other approach that we described earlier for you, the ADA website accessibility would apply to a nonprofit giving away goods or services.
All right. There's been references made to the WCAG, and there was a reference made by Ken to 2.0 as being the standard that defendants are most likely going to be held to. But there's also references to the 2.1 standards, which are new. Can you say something briefly about what the difference is and whether we should care?
Sure, yeah, keep 2.1 on the horizon as something to look out for. The techniques haven't really been fleshed out as thoroughly as they could be by the W3C, so we don't really know exactly what people are expecting around how to achieve 2.1. In terms of the differences, there are 38 success criteria and 12 guidelines. Those 38 success criteria fall into 12 guidelines under WCAG 2.0, and I believe it's about 50 success criteria under 2.1 that fall under 13 different guidelines. So it's a little bit more fleshed out, but there's a substantial amount of carryover. So all those original 38 are as part of the new 50. So really, though, every settlement agreement is still focusing in on 2.0 because that's really where that's really established. So I'd say stick to 2.0, but just keep 2.1 in the back of your mind.
On my watch, we have hit our deadline. So again, I invite those of you who have questions. We'll take whatever questions we've got and forward them. And if you have any additional, you can forward them to us, and we will follow up individually. I'm going to conclude with a brief, thunderous closing sermon that's primary virtue is that it's brief. Website accessibility may be a challenge, but as I think you've heard the panel say, it may also be an opportunity. Nick was talking in numbers of 250 million people around the globe who may qualify as having the kind of impairments that we're talking about. You heard Ken talk about the demographic trend that suggests it's going to be more and more people who are looking to be able to access websites they may not currently be able to access. We don't pretend to know your businesses. We don't pretend to know everything your organizations need. But what we will pretend to say is this warrants your close attention to see if there's an opportunity here to be obtained, even while you're engaging in complying with this ever-evolving law. And Ken, I suspect, would be the first to tell you that the cost of designing a website that's accessible to people with visual impairments pales in comparison to the cost of redesigning such a website. To all of you here with us and on the webinar, thanks for listening in.